Hi, everyone. It's Dr. Nonnie here. I'm your friendly family physician, and I always like to bring you reliable but simple health and lifestyle advice. So, for those of you who are new to the channel, I want to say a big thank you for tuning in, for joining me today, and welcome. And today I'm going to talk about something that's a bit grim, but hopefully we can make it a little bit more, give you more understanding in this area. And before I welcome my guest, who is a very learned gentleman, I want to first of all start by saying, drum roll. I thank God I have now hit 40,000 views. So this is my fourth year of YouTube. We've reached 5 continents, 40,000 views. To God be the glory. So I'm really excited. And I'm looking forward to doing more. If you're new and you like what we're doing, please, and you have a YouTube account, kindly just hit that subscribe button. Just encourage us as we produce so that we can keep doing this for you. And so, as I said earlier, I'm joined by a very learned gentleman. He's in the person of Barrister Reginald Anteson. Barrister, you're very welcome.
Thank you, ma'am.
Yes. So Barrister Anderson is he's dual qualified. So he's both a barrister as well as a solicitor, and he is our local solicitor because I'm still in the UK. Canadians, don't worry, I'm coming back. I'm coming back. So I'm still in the UK, and on our high street we have a legal firm, Herbert Solicitors, a group of very friendly solicitors who give expert legal advice. And I thought, do you know what? As a GP, people come to me, we look after people from cradle to the grave. And what about wills? Death is something that will happen to all of us. We all know the saying that death and taxes are the things that always happen. And so before you die, because unfortunately, the news is very grim these days, people just dying, celebrities, people in the war, people going on the streets about their daily disease, some of them unplanned deaths, some of them planned deaths. But one thing we all know, we are all going to die. But if you die without leaving a will, well, that is not good. And that is what Reginald is going to be sharing with us today. So, Barrister, you're very welcome again.
Thank you. Thank you, Dr. Nonnie. It's a privilege to be on your program, and I'm very, very grateful for you
Thank
to
you
give
so
me
much.
this opportunity to express myself on
Good,
wills.
good, yes.
Right.
So, as we said, I'm going to hand over the floor to the learned gentleman. I'm just going to learn as well. So, just tell us, Barrister, what is a will? What does this even mean?
Yes, in the legal term, we describe it as a what we call testamentary disposition,
Right.
which is the instruction that after your death, the way you want your affairs to be managed, you know. And people always think that wills should only be written by people who are in their old ages, or those
Mm.
who, or if you write a will, then it means you have a premonition of death. That people will talk about, no, you're going to die soon. No, but that is not it. It is putting your affairs in place so
Mm.
that obviously if the inevitable happens, you
Mm.
know that you have put certain things in place.
Mm.
It, and most of you'll be very much surprised that when you don't write a will, especially when you have dependents, there's always this idea of infighting. So it's better to have a will that would be able to take care of your affairs after we've departed. Because it's often said that the most certain thing about life is its uncertainty. We can always
Mm.
pass at any time. So we should be ready than to leave things in abeyance. I mean, before I go on, there's this case of a very famous Nigerian barrister, Rotimi Williams,
Mhm.
who, after 10 years of his death, his children are still fighting over
Mm.
his property. And this is,
Mm.
it's a very sad thing, you know. Even when there's a will, there's even a problem. So how much more
Mm.
if you don't write a will at all?
Mm.
You know, so
Mm.
this is what I can say. So it's imperative that
Mhm.
everybody, regardless of your age, as
Mhm.
long as you're over 18, I would
Mhm.
encourage everybody to have a will in place. Because
Over
in my
18,
will
what do
bank
they
here,
have to bequeath? What does an 18-year-old have to leave anyone?
but as to how the affairs should be managed, because
Oh.
in my will bank here, I have over 400 wills in the it's going about 500, and some of them date back 20 years, 30 years.
Yes.
So it's just to get that tag of people thinking that if I write a will, it means I'm going to die tomorrow. That is not the fact. It is putting your affairs in place. And even if the will is written and you decide to, your situation changes, there's something we call a codicil, which is you don't have to rewrite a new will, but you can make an amendment to the old will, which we call a codicil, which is an addendum to the will. So this is what we have been trying to encourage the community to come up and draft their wills.
Yes, I mean, I have to really add my voice to this. I remember when I was a trainee doctor, we're talking about nearly 20 years ago, and the British Medical Association at the time offered us lots of financial advice, and one of them was will writing. And I took up the offer, I have to say, at the time, and the children I was writing the will for are now adults. So it's just to buttress the barrister's point that writing a will doesn't mean you are going to die. But I think even as a parent, it's a responsible thing to do because, every day we go out and we come in and we're driving or flying or what have you. And we just don't know. The future is not something we're not privy to, right? So I think it's just wise. So, Barrister, if one doesn't take up your good advice and write a will, what are the problems that can ensue? I mean, is it really a big deal to write this will? Or are you just
Yeah,
trying to
well,
get some trade?
yes, there are lots of problems which comes. In the first place, if you don't write a will, then you would allow the state to determine how your assets are going to be distributed. So if, for instance, you die intestate, then that is where the families come. And especially with our background, but you'll be amazed that human nature as it is, whether black, blue, white, or green, they would always fight over property. So if you fail to write a will, then the legislation, the government in this country, we have what we call the non-contentious probate rule 20, which governs intestacy. If you don't write a will, you're deemed to have died. We refer to it as intestate. That means you didn't write a will. So what the law requires is that the law is going to look at, there's an order of priority as to who should be entitled to even apply for whatever letters of administration to govern the property. And if nobody is found, then there's what we call bona vacante. Your assets goes to the state in this country. So it's very imperative that we should have this will in place and not to allow the state to determine who should apply for letters of administration and how their assets should be managed. Because once you don't write a will, then the non-contentious probate rule 20, 1987 kicks in, so that the state will regulate who should have your property and who should not. And it could be that it could be an auntie whom probably you've been at loggerheads with, what you don't want her to have your property, might end up having your property, or an uncle somewhere. You see, so it's important. Although they say when you're dead, you don't know what happens, but then you'd want it to go to the loved ones that you want them to have. Yeah.
And honestly, I can't really overemphasize this. I think it's so important, almost irresponsible, especially when you have children and if they're young, to make sure that they're protected, just like you would take out life insurance. So that's why I wanted to bring this video and this educational piece for you to learn from. And the good barrister agreed to be on the show. So, barrister, you know how it is when you're looking for a boss, and then all of a sudden you start seeing bosses everywhere. So while I was preparing for this meeting, the next thing I started seeing lots of adverts popping on my phone, make a will for 1999. I thought, Why am I paying hundreds where there's 1999 will? So please tell us, what is the difference between going to a solicitor or just going to WH Smith and buying one of the will writing packs, or clicking on the YouTube ad for 1999?
Yes, I'm glad you brought up this question because this issue, because there's been so many, we've had clients here who come to this office who had fallen for bait for this 999, only to come back to realize that it was just, I would say, I wouldn't call it a scam, but then it wasn't what it said it was. Because we had one client who came in who was informed that she was going to 19 pounds, as he said. And then after they really induced her to set up a trust, which wasn't necessary because she only had one daughter who was grown. But they said, no, you need to do this trust, you need to do this, the rest, you need to do that. And then in the end, her bill came to about £2,000. And she was very hysterical. So we had to call her down and then even advise her to make a complaint to the trading standards, just to make sure that these adverts are taken off. Because no will worth its salt will be £19. That is ridiculous. Because when they come, sometimes you have to look at it, advise them, and sometimes even you advise them the impact of having and the impact of the tax brackets. I mean, there are also tax issues in this country as to how much, what do you call it, nil rate ban, to explain to them that, I mean, what your dependents can claim after your death. So it is very, very simplistic for someone just to go into WH Smith, get something, and then just write, I give my entire access to. No, there should be specialists to tell you that probably tax is payable on your properties, what you could put in trust. I remember one recent will that I did where the grandmother actually decided to leave her entire estate to her grandson, who was only 4 years old. And so she had to set up a trust. She created for it this trust and stated that the grandson should not attain until he attains 21. So this is a 4-year-old boy who is now going to, by the time probably he's 21, he'll be a millionaire, But if you go to probably these areas and then you pick up a form from WH, how would you know how to set up a trust and all these things? But you need the professionals to explain these things to you. So I would advise anybody that if they see that advert saying you don't need a solicitor to write a will for 19, they should take it with a pinch of salt. Yeah, that is what I can say.
And I have a question here, actually. I'm just going to read it to you because when I told someone at the end, they were saying something about they got one of these adverts actually, and got the will done, but haven't signed it. So if you don't sign it, is it valid?
Well,
so
if
say you
don't...
haven't signed it, you're dilly-dallying, and God forbid you went out and something happened, but you wrote it down. It was all written down. You spoke to someone over the phone, but you didn't sign. What happens then?
It does not conform to the requirements of a valid will. Because the valid will, which, I mean, the Will Act of 1837, as amended in this country, gives 4 conditions on which a will can be valid, in the sense that the testator must be of sound mind, must have legal capacity, And then for this thing is that then there should be witnesses, at
Mm,
least two witnesses. And also what I want to say is that a beneficiary cannot witness a will.
mm,
Because once, if you're a beneficiary under the will, it's
mhm,
like maybe you want to write your will, or your will has been drafted, and then you call your daughter to come and witness it.
mm,
That gift in the will to your daughter would fail.
mm,
Now, it's only if there are more than three signatures,
mm,
then the will become valid because then her signature would be taken as superfluous.
right.
But then the more normal requirement is to have two independent witnesses who are not
Mm,
connected to the testator. The reason being
mm,
that if, for instance, your daughter witnessed it, it
mhm,
could be that probably she coerced you or applied some pressure on you.
mhm, mhm.
So we always advise against a beneficiary witnessing the will. Yeah.
Yeah, yeah. Okay, so we're almost coming to the end of our time, and I really appreciate how you've explained everything so nicely for us. You've broken down all the legal jargon. But can you just maybe end with something about trust? So, who should have a trust? Is it anyone who has property? And maybe also touch on, if do you need to make a will in every country that you live in? Because now many people, the world is quite small, as they say, it's quite
Yeah,
global. Many
yeah,
people
because
have
of
property overseas and things like that.
because there are two things. Well, in administrative purposes, most people, because of different jurisdictions, most people, especially those of us with dual nationality, sometimes we think it's more efficient to make two different wills, one for the other country and one for the UK. But then again, if you're a UK citizen and then you make a will, and the will can cover anywhere in the world,
Mm,
you know, and what it is that tax is payable even in your assets, be it in Ghana or Nigeria, it will be subjected to UK jurisdiction. And
mm,
so I think the UK has tax treaties with various countries in which sometimes this double taxation does not take place.
mhm,
But then it's always advisable to look at the extent of your estate and you decide whether it's practical to have two different wills. And when you're
mhm,
doing that, you would probably decide to exclude that this will is valid only for my assets in the UK. And then there's a limitation effect that it does not affect anywhere. But once it's made and it's a general will which takes every access, then the the home state where you're domicile is
mm,
entitled, tax is payable, whether the property is in Timbuktu, wherever it is still comes under UK's jurisdiction, and especially where the person is domicile here or a
mm,
citizen of this country,
mm,
you
mm,
know. And in terms of trust, well, a lot of there are pros and cons in terms of what we call, but most people would go in for what we term as discretionary trust. But it's a very, very complicated area, and
mhm,
we would have to find time to look into the nitty-gritty of that, you know.
mm,
But then it's always advisable, like what I said concerning the lady, and especially where the children are young,
mm, mm,
and you want to leave property, it's always better to put it in a trust, you know, and there could be specifics as to whether the trustees can use some of the money to help in the education of the child.
mm,
And then probably the beneficiary or the child trust would probably, you can specify that at age 18, he can receive income from whatever property that is in trust. But then when he probably attains age 25, then the thing is deemed to be more matured. And then he can sort of have income, the whole thing vested in him. Because years ago, I remember one boy who actually had yes, the father actually put did a premium, insurance premium in his name. And the thing said that, okay, at 18. So when the dad died, he was about 17, still a minor. So he could not, but the moment he turned 18, he went behind his mother, contacted the insurance company to say he was at age. So they paid him almost getting to between 50, I can't really remember. And within 3 weeks, he has spent the entire money.
Oh my word.
Yeah. I understand he bought a car, took his girlfriend on vacation, and the next thing they realized the money was gone. So that's why it's always better to put things right and then, I mean, and the last thing I want to talk about is the executors of the will.
Yeah.
This must be trusted people. Because I have seen, even on program in the UK, where once a soldier who apparently died, but went to Afghanistan, one of these soldiers, and he had his fiancée, he had given almost everything to his fiancée in his will, but had named his mother as the executor of the will. And God knows, the mother actually went to prison. She got the probate all right, got the letters of administration, and decided to go on a frolic of her own, big lifestyle. So, and I was following it on telly, and I realized that, I mean, even I'm sure at the time he nominated his mother as the executor, he didn't think the mother would not even give his fiancée anything. So it's very, very important that if we are writing our will, we've got to be careful the kind of people that we appoint as executors. But then the law also allows the beneficiaries where the executor misconducts himself or herself, they can make an application to court to have the executor removed. So it's not a permanent position for the executor. And in most cases, where the executors are professional, some like to use solicitors to be their executors, they owe a duty. And then they can also charge for the work, the professional from the estate. But where the executor is somebody that a family friend or cousin or something, they cannot charge for managing the estates, but they are allowed to take reasonable expenses in their everyday, I mean, to meet their needs. For instance, he has to do this, take a taxi, collect the estates and things. Yeah, they can take what we call reasonable remuneration for their time, So I'd love to come back on this program this time, and so that we will talk well on trust, because it's a topic very dear to my heart as well.
Oh, really? Okay. So that's it. So we have a deal. So at this point, I think it's a lot we've learned today. So we've learned that it's important to make a will, otherwise you die intestate. You don't want to be that. We've seen that anyone can make one from the age of 18, because it's not just talking about your property. I was teasing about 18-year-olds, but there's some 18-year-old child actors or musicians who have money. And also, it's also to tell people how, if you passed on, you died, what you want to be done. Do you want to have a burial, cremation? Do you want to be buried here, there, or everywhere? So it's not just money, right? It's just saying your wishes. And so we can see that it can be quite complex. But fortunately for us, we have someone like Barrister here who is obviously very experienced and knowledgeable in these matters. And so I'm going to leave his address. It's Herbert Lewis Solicitors. It's on our Bournemouth High Street. I'll leave the telephone number and the details in the description. Please, 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 especially my African audience. Like I said, we have audience in 5 continents, but the African audience in particular, who do not want to hear anything about death, please, we are all going to die one day, and we should make sure we put things in place. And on that note, I'm just going to say goodbye. And the barrister, you want to say goodbye?
Goodbye. And just to emphasize what you said, that you have child actors. And what about the footballers? Some of them
Yes.
16 on millions.
Wow.
So they have to be advised, and all these young bosses, and how to put their monies in place, so that if the inevitable happens,
God forbid,
because I can even attest that my dad, who was a very learned man, a professor of medicine, and I remember when he had the stroke, I went to see him, and he ended up not signing his will, but at least we knew what was in the will, But sometimes, if we didn't have a very united family, we could have also been torn into litigation, endless litigation, And especially with families where there are stepchildren, have siblings, and all that. It's very important that the intention of the testator is put, and don't leave it to chance. That's all I can say.
Yes. So a word, as I say, is enough for the wise. Basically, all of you, you finish this video, you click subscribe, you get an appointment for your will. All right. So next time.
Okay. Thank you, Dr.
Thank you.
Bye-bye.
That I've gotta make a change. I don't care if I break, at least I'll be feeling something. Just okay, it's not enough. Help me fight through the nothingness of life.